Warning: this article discusses the recent bar exams and may be triggering for some readers. Proceed at your own risk. For the recent bar exam takers, I'm going to give you 10 seconds to decide whether you will want to proceed or not. Okay, let's proceed. Disclaimer: this video is designed to provide suggested answers to the bar examination questions. The video is not intended as a complete or definitive guide to answering every possible question on the exam, nor is it legal advice. This video is produced for entertainment purposes only. Viewers should not rely upon the information presented in this video as legal advice. Although the video is accurate to the best of our knowledge, as to the date of its production, the law changes constantly and viewers should consult an attorney for specific legal advice. Separate, concurring, and dissenting opinions are encouraged in the comment section. Question number 1. A police officer saw Harvey urinating in public. A local ordinance imposes a 500 peso fine for urinating in public. The police officer shouted at Harvey, "That is against the law!" Harvey sarcastically answered, "No, it's against the wall." Then and there, the police officer arrested him and brought him to the police station. At the police station, Harvey was frisked and was found in possession of an unlicensed 38 caliber revolver loaded with 5 live ammunitions. He was subsequently charged with qualified illegal possession of firearms. When the prosecution offered in evidence the unlicensed firearm and ammunition, the defense objected on the grounds that the pieces of evidence are products of an illegal search and seizure. The prosecution contended that the pieces of evidence were lawfully seized after a valid warrantless search incidental to a lawful arrest. Was the search and seizure valid? For 5 points. No, the search and seizure is not valid because it was not a search incidental to a lawful arrest. Jurisprudence dictates that there can be no valid arrest if the offense merely imposes a fine. Even if it were true that the accused did urinate in public, the police officers involved in the case still conducted an illegal search when they frisked Harvey for allegedly violating the regulation. It was not a search incidental to a lawful arrest, as there was no or there could not have been any lawful arrest to speak of, based on the case of Picardal versus People. Pedro was accused in a rape case. During the trial, the private complainant testified on the night of the incident. She was walking home when Pedro, who was her neighbor, suddenly grabbed her and brought her to his house. There, Pedro forcibly had carnal knowledge of her. After the prosecution rested its case, Pedro testified that the sexual intercourse between him and the private complainant was consensual. Eventually, the court acquitted Pedro on reasonable doubt and found that the element of force was not established. The people filed a Rule 65 petition for certiorari with the Court of Appeals, alleging that the trial court's decision was rendered with grave abuse of discretion because the private complainant's testimony clearly established that Pedro had carnal knowledge of her through force and without her consent. In his comment, Pedro sought to dismiss the petition on the ground of violation of his rights against double jeopardy. As the Court of Appeals, how would you rule on the petition? Explain briefly. The CA should deny the petition because it will violate Pedro's right against double jeopardy. A decision of the Supreme Court states that if the petition for certiorari, regardless of its nomenclature, merely calls for an ordinary review of the findings of the court a quo, the constitutional right of the accused against double jeopardy would be violated. Here, the petitioners failed to establish that the judge committed a grave abuse of discretion amounting to lack or excess of jurisdiction. They merely restated the testimony of the private complainant. This issue was already passed upon by the court based on the case of People versus Alejandro. A city ordinance was passed providing for the removal at the owner's expense of, first, all advertising materials displayed or exposed to the public in designated regulated areas such as residential zones, bridges, and along main city streets. And second, billboards of substandard materials or which obstruct road signs and traffic signals. Failure to comply with the said ordinance authorizes the mayor, assisted by the police, to implement the removal of the non-compliant materials. ABC ad agency owner of the billboards removed by the city filed a complaint because considering the nature of its business, the removal of its billboard amount to the taking of private property without just compensation. Will the complaint prosper? Explain briefly. No, the complaint of ABC ad agency will not prosper because the city ordinance passed is a valid exercise of police power. As a rule in constitutional law, an ordinance constitutes a valid exercise of police power if it has a lawful subject such that the interests of the public generally as distinguished from those of a particular class require its exercise, and b. it uses a lawful method such that its implementing measures must be reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. Here, the ordinance satisfied the first requisite by seeking to regulate all signs and sign structures based on prescribed standards as to its location, design, size, quality of materials, construction, and maintenance. Further, it complied with the second requisite by employing rules and implementing its policy, based on the case of Evasco versus Montañez. This item has two questions. As a reaction to China's occupation of the Spratly Islands, a rally was organized by various civil society agrupations at a vacant private lot. Before the event could even start, the police ordered the organizers not to proceed with the program because of security reasons, and the fact that the group did not have a mayor's permit. When the organizers still proceeded with the rally, the police dispersed the crowd and arrested the leaders of the group. A. Did the actions of the police constitute a violation of the group's constitutional right to peaceably assemble? Explain briefly. No, the actions of the police did not constitute a violation of the group's constitutional right to peaceably assemble because they are merely implementing the law. Under Public Assembly Act of 1985, generally a permit is required to hold a public assembly in a public place. While the same law removes this requirement if the assembly is done in a private property, the consent of the owner or the one entitled to its legal possession should be secured. Absent this condition, the general rule applies. Question 2. Would your answer be the same if the rally was held in a Freedom Park? Explain briefly. The answer will not be the same if the rally was held in a Freedom Park. The Public Assembly Act of 1985 states that no permit shall be required if the public assembly shall be done or made in a Freedom Park duly established by law or ordinance. The K-12 law was passed with the objective to enhance the Philippine educational system by strengthening its curriculum and adding 2 years of high school. Parents of students in a science high school sought to have the law declared unconstitutional, citing the Equal Protection Clause of the Constitution. As well, the parents averred that the law should not apply to their children because the latter belonged to a distinct class, being gifted and advanced for their age, with the capability to learn better and faster compared to other high school students. Is the contention of the parents tenable? Explain briefly for 5 points. The contention of the parents that the K-12 law is violative of the Equal Protection Clause is not tenable because the ASAIL law is not infirm in treating all high school students equally. A ruling of the Supreme Court states that the Equal Protection Clause is directed principally against undue favor and individual or class privilege. It does not require absolute equality but merely that all persons be treated alike under like conditions, both as to privileges conferred and liabilities imposed. Here, the Science High School students did not offer any substantial basis for the court to create a valid classification between them and the rest of the high school students in the Philippines, based on the case of Katescoop versus Secretary of Education. President Hidalgo, who wanted the Philippines to be part of the International Criminal Court once again, signed the Philippines' ratification of the Rome Statute. A copy of the treaty along with the ratification was sent to the Senate for its concurrence. Senator Dalisay filed a proposed resolution for the Senate to concur with the Philippines' ratification. The proposed resolution was read 3 times on 3 separate days. 3 days before the third reading, printed copies of the proposed resolution in its final form were distributed to the senators. The senators then unanimously approved the resolution and the Senate expressed its concurrence with the treaty's ratification. A civil society group filed a petition before the Supreme Court questioning the validity of the Senate's concurrence on the ground that the resolution was void because only a bill becomes a law. Rule on the petition. Explain briefly for 5 points. The civil society group's petition is without merit because the concurrence made by the Senate pertains to the treaty itself and not the resolution. Based on the doctrine of incorporation, the Philippines adopts the generally accepted principles of international law as part of the law of the land. It starts its binding effect upon signing of the treaty by the President and upon concurrence by the Senate. With these 2 steps completed, the treaty now becomes part of the law of the land. After martial law was declared over Mindanao, police officers arrested Jose Maria without any warrant while shopping for groceries at a supermarket in Mindanao. Jose Maria questioned the validity of the arrest as he had no pending case and was not committing any crime at the time of this arrest. The police officers countered that the declaration of martial law suspended the privilege of the writ of habeas corpus and, as a result, they could effect warrantless arrests. Is the contention of the police officers correct? Explain briefly for 5 points. No, the contention of the police officers is not correct because the Constitution prohibits the suspension of the privilege of the writ of habeas corpus unless specific circumstances warrants it. Article 3 of the 1987 Constitution states that the privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. The declaration of martial law does not suspend this privilege. A law was passed exempting the Land Bank of the Philippines, Huron LBP, from the payment of filing fees in collection cases on loans granted by LBP to its borrowers. The Office of the Court Administrator, Huron OCA, of the Supreme Court issued a memorandum requiring all courts to continue to collect filing fees in collection cases filed by LBP, stating that only the Supreme Court can decide on exemptions from payment of filing fees. LBP assails the OCA memorandum arguing that the exemption found in the law is within the plenary power of Congress to enact legislation. Moreover, the law was approved by the President. Thus, LBP argues that the act of the OCA violates the principle of separation of powers. Is LBP correct? Explain briefly for 5 points. LBP is not correct that the act of the OCA violates the principle of separation of powers because the 1987 Constitution grants the Supreme Court the power to promulgate its own rule on procedure in all courts. Section 5, Article 8 of the Constitution grants the Supreme Court the rule-making power over the rules on pleading, practice, and procedure in all courts, which includes the sole power to fix the filing fees of cases in courts. During a press conference, President Acosta explained that the executive department can temporarily take over the operation of any privately owned public utility or business affected with public interest to address the shortage of hospital beds occasioned by COVID-19 pandemic. She invokes Article 12, Section 17 of the 1987 Constitution, which provides that in times of national emergency, when the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. Is President Acosta correct? Explain briefly for 5 points. President Acosta is not correct because Article 12, Section 17 of the 1987 Constitution is in the nature of an emergency power. As such, it is vested with the legislature and not the executive department. Jurisprudence states that generally Congress is the repository of emergency powers. This is evident in the tenor of Section 23, Paragraph 2, Article 6, authorizing it to delegate such powers to the President. Lemuel was born in 1988 to a Filipino mother and an American father, as shown in his birth certificate. His parents, however, were not married to each other. Subsequently, his father petitioned for him, as a result of which Lemuel received a certification of American citizenship and an American passport. In 2022, Lemuel filed a certificate of candidacy to run as representative of the Lone District of Batanes. Ayla, a Filipino citizen and resident of Batanes, filed a petition for disqualification with the Commission on Elections, alleging that Lemuel is ineligible to run for public office in the Philippines as Lemuel is an American citizen. Is Ayla correct? Explain briefly for 5 points. No, Ayla is not correct in alleging that Lemuel is ineligible to run for public office in the Philippines as he is an American citizen because the latter is a dual citizen by birth. The Citizenship Retention and Reacquisition Act only applies to dual citizens by naturalization. Hence, Lemuel did not reacquire his Filipino citizenship since he did not lose it in the first place. He is therefore eligible to run for office in the Philippines. The Commission on Higher Education directed higher education institutions to remove materials that contain pervasive ideologies of communist terrorist groups from their libraries. According to CHED, the materials needed to be removed because these would radicalize students against the government. Is the CHED directive a violation of the institution's academic freedom? Explain briefly for 5 points. Yes, the CHED directive is a violation of the institution's academic freedom because it impedes on educational institutions' freedom to choose what may be taught. Jurisprudence states that the essential freedoms subsumed in the term academic freedom encompasses the freedom to determine for itself on academic grounds 1. Who may teach, 2. What may be taught, 3. How it shall be taught, and 4. Who may be admitted to study. Chad's directive impedes on the educational institution's prerogative to choose what to teach, based on the case of Sun et al. Versus UST. Congress passed a law prohibiting the sale and distribution of alcoholic drinks within 100 meters from religious and educational institutions. A city enacted an ordinance increasing the coverage of the prohibition to 150 meters from any religious and educational institution. Is the city ordinance valid? Explain briefly for 5 points. Now, the ordinance increasing the coverage of the prohibition from 100 to 150 meters from any religious and educational institution is not valid because it is not consistent with public policy. Supreme Court rulings in this matter states that a valid ordinance must first not contravene with the Constitution or any statute. Second, must not be unfair or oppressive. Third, must not be partial or discriminatory. And fourth, must not prohibit but may regulate trade. Fifth, must be general and consistent with public policy. And sixth, must not be unreasonable. Here, the existing law enacted by Congress specifies a specific coverage of prohibition, 100 meters, from any religious and educational institution. Thus, the local government cannot increase this coverage because, while it is arguably unreasonable and may regulate trade, this is not consistent with public policy, based on the case of White Light versus City of Manila. Pursuant to a law ordering the fixing of just and reasonable standards, classifications, regulations, practices, or services to be furnished, observed, and imposed by operators of public utility vehicles, the Land Transportation Franchise and Regulatory Board promulgated and published a regulation that no car beyond 6 years shall be operated as a taxi. Taxi operators assailed the validity of the regulation, contending that procedural due process was violated because position papers were not asked of them and no notice was given to them prior to the issuance of that regulation. Were the taxi operator denied procedural due process? Explain briefly for 5 points. No, the taxi operators were not denied procedural due process because the standard of due process that must be met in proceedings before administrative tribunals allows a certain latitude as long as the element of fairness is not ignored. A foreign commercial ship was spotted by the Philippine Coast Guard dumping garbage and toxic waste 20 nautical miles from Nasugbu, Batangas, the nearest coastline of the Philippines. The officers of the ship were arrested and charged in the Regional Trial Court of Batangas for violation of environmental laws of the Philippines. The officers of the ship filed a motion to dismiss the case on the ground that Philippine courts do not have territorial jurisdiction over the case since the vessel was sailing outside the territorial sea of the Philippines when the arrest was made. Is the ground to dismiss correct? Explain briefly for 5 points. No, the ground to dismiss is not correct because the foreign commercial ship was caught dumping garbage and toxic waste within our contiguous zone. Under the United Nations Convention on the Law of the Sea, the coastal state has control over the contiguous zone which is limited to preventing or punishing infringement of its custom, fiscal, immigration, or sanitary laws and regulations within its territory or territorial sea. Hence, the officers of the ship are not correct in stating that Philippine courts do not have territorial jurisdiction over the case, since the vessel was sailing outside the territorial sea of the Philippines because the arrest was made within our contiguous zone. This item has 2 questions. Philippine Medical Center here on PMC is a government hospital created by law to provide health care to the general public, especially the less fortunate. To enable PMC to perform its mandate, the national government provided the initial capital, land, buildings, and equipment to the PMC. PMC's charter also authorized it, acting through its board of trustees, to acquire property, to enter into contracts, to mortgage, encumber, lease, sell, convey, or dispose of its properties, and to do other acts necessary to accomplish its purposes and objectives. Among the properties of PMC are 5 lands and buildings located in Quezon City. The Quezon City assessor issued notices of assessment for real property taxes against the PMC's property that are being leased to private concessionaires. According to the city's assessor, PMC's properties leased for private entities are subject to real property tax because these properties are not being exclusively used for charitable purpose. PMC, on the other hand, claims that as a government instrumentality imbued with corporate powers, it is exempt from real property tax. First question. Is PMC liable for the assessed real property tax over the leased properties? Explain briefly. No, PMC is not liable for the assessed real property tax over the leased properties because it is the private entities whom the beneficial use was granted who are liable for the payment of real property tax. Section 234A of the Local Government Code exempts real property owned by the Republic from real property taxes, except when the beneficial use thereof has been granted for consideration or otherwise to a taxable person. Thus, the court has invariably held that a government instrumentality, though vested with corporate powers, are exempt from real property tax, but the exemption shall not extend to taxable private entities to whom the beneficial use of the government instrumentality's properties has been vested. Based on the case of Philippine Heart Center versus QC. Question number 2. Supposing PMC is correct that it is not liable for real property tax, may the city assessor assess the lessees for the RPT in 3, 2, 1. Supposing the PMC is correct. So, in 3, 2, 1. Second question. Supposing PMC is correct that it is not liable for real property tax, may the city assessor assess the lessees for the real property tax due on PMC's leased properties? Explain briefly. Supposing PMC is correct that it is not liable for real property tax, the city assessor may assess the lessees for the real property tax due on PMC's leased properties because it is the taxable person with beneficial use who shall be responsible for the payment of the real property taxes due on the government properties. Any remedy for the collection of taxes should then be directed against the taxable person, the same being an action in personam, based on the case of Philippine Heart Center versus QC.